It's a medical malpractice trial. My client is on the witness stand and I'm asking my client questions. As I ask my client a question, he gives me the wrong answer. Can I turn around to my own client during direct examination and say, wait a second, Mr. Jones, are you really sure that's the answer? You want to know the answer to this? Come join me for a moment as I explain to you exactly what the answer is. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is no, I cannot go ahead and tell my client that the answer he just gave is absolutely wrong. I can't do that. I cannot put words in my client's mouth. This is my client on the witness stand. I'm asking my client direct questions, meaning I'm asking him open-ended questions. Mr. Jones, tell us what happened. What did you do next? Tell us what happened then. How did that happen? Now I give my client the opportunity to go ahead and explain to the jury exactly what occurred in his own words. What happens if my client has an issue remembering a key part of his testimony? There's one fact that he really needs to get the jury to know and to learn about, and he tells them the wrong thing. Can I simply stop him and say, wait a second, that's not right. You told me just a couple hours ago, in fact, you told me a few years ago when you first met me that that didn't happen. Now you're telling us it did happen? Now the defense attorney is jumping up, screaming, Judge, he can't do that. He's putting words into his client's mouth. He's trying to correct the testimony. And the defense lawyer would be absolutely right. I can't do that. That's not my place. However, you should know there are different strategies to try and fix this problem. One of them is to show to my client, hey, Mr. Jones, I understand it's been a number of years since you last gave testimony during your pretrial question and answer session known as a deposition. Let me show you on page 12, line 7, exactly what you said when you were asked this question. On this particular date, at this particular time, did you go here? And now tell us what your answer was at that time. And now he's going to look at it and says, oh, yes, that's right. On that date, I told my answer was X, Y, and Z. And I say, Mr. Jones, you just told us something different. Now it gives him the opportunity to explain to the jury that he just forgot that for a moment. Now, I will tell you, the defense lawyer is going to seize on that, and when he gets up to cross-examine him, he's now going to put him through the ringer to say that he told us one thing 2 years ago, and now he told us something different, which one is correct, which one is not correct, and now he'll try and make him out to be a liar. But the reality is, people are not robots. We're not computers. We get up on the witness stand, it's an uncomfortable place, it's a foreign place. Most people have never taken the witness stand. Now you're sitting in a room full of strangers, talking to 6 people of the jury, and now you're being asked questions in a formal setting. You know what? People do forget. They may not remember the exact thing that they said 2 years earlier. They may not remember what happened to them during a particular incident or what someone said to them. And now they say something that clearly is different than what they said just a little while earlier or a couple of years earlier. So now there are different ways to try and refresh their memory, to try and get them to remember, oh, by the way, yes, you did say something different a few years earlier, take a look at it. Does that refresh your memory as to the answer that you gave in response to that question? Yes, it does. Great. So which answer is the correct one? And now we'll go ahead and explain. So why do I share this quick information with you? I share it with you because this does happen from time to time in these civil lawsuits involving accident cases, medical malpractice cases, and even wrongful death cases here in New York. You know, I recognize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but have not done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.